Hello, everybody. My name is Rod Escaola, and I'm your condominium lawyer with Gowling WLG. Let me start by welcoming you to our October edition of your monthly condo webinar. Now, this time around, I got to tell you, we had planned on not talking about COVID, yay, and we wanted to focus on the Condo Tribunal's new, expanded, new and exciting jurisdiction. But as COVID would have it, here we are again, dragged into the COVID hole, because there's been all sorts of changes, new regulations, and new restrictions, changing restrictions, amendments to the restrictions. Some cities are included, some cities are excluded. And so we thought, okay, well, what about if we start with just a small COVID update? And so we're going to split tonight's webinar in two. We're going to have our COVID update, can do without, and we are also going to focus on the Condo Tribunal's new jurisdiction. It's excited to hear about them. Now, as usual, what we've done, we've called our trusted experts to join us tonight, with the notable exception of Denise, who is off tonight. She's taking a break, but fear not, she sent someone to not quite replace her, but our new guest, Natalia, is going to blow your virtual socks off when she talks about the Condo Tribunal. Now, keeping with our tradition, we needed a theme to introduce our panelists, so we got a suggestion from a property manager at the regional group from Val Komenko, who suggested that we would go with the famous 60s people. Love a challenge? Now, none of us being born in the 60s, with one notable exception, but I'm not going to point the finger. We had to Google some of that stuff, so you'll have to bear with us here. Now, first and foremost, from Apollo Property Management, reminding owners not to ask what the condo corporation can do for them, but what they can do for the condo corporation, Sean JFK Cornish. Hi, Sean.
Hey, Rod. Good to be back and good not to be the newbie anymore.
Nice, nice. You sound better than yesterday. Yesterday you had a bit of a sore throat. Now, from Crossbridge, speaking on behalf of ACMO, the Julie Andrews of Condo Management, Catherine Poppins-Gow. Hello, Catherine.
Hello, great to be with you all tonight again.
Stepping in for Denise from Lash Condo Law, having AGMs at Tiffany's, Natalia Hepburn-Polis. Hi, Natalia.
Hi, everyone. Thanks for having me.
I don't see you, but I assume that you're there somewhere.
Yes.
Yeah, she's here.
Okay, she's here. Okay, well, you should see my setup here. I have enough screens to feed a family. Now, our condo twins, both condo lawyers at Gowling's WLG, the Che Guevara of governance, Graham McPherson.
A revolutionary always.
That's right, and keeping the Yankees at bay, the second twin, David Castro-Plotkin. Hi, David.
Oh boy, hello.
Finally, he was supposed to take the evening off, but I called him at midnight, literally last night, and he put his cape on straight from the National Life Safety Group with a mean uppercut to Jason Mohammed Ali Reed. How, Jason? How's it going?
Fantastic. Thanks for having me.
Okay, so if you have questions, you can use the chat line. If you want the question to be ignored deliberately, you can use the Q&A section. And to ensure that we don't get in the shuffle, David and Graham and Catherine will monitor those means. Now, before we jump in, your favorite part of the webinar, our disclaimer. So for those of you watching this webinar, keep the following in mind. First, when we talk about legislation, we refer to Ontario legislation, and even at that, sometimes we refer to smaller portions of Ontario. Those listening from elsewhere, you'll have to maybe adapt some of what we say. The information we provide to you tonight is as accurate as can possibly be on October 7th, 2020. Most importantly, keep in mind that the information we provide tonight is just...
Rod, your sound cut out for a minute there, but I think what you were probably going to say was that it's general in nature. And looks like...
Current as of the day of broadcast and subject to change at a given moment's notice on account of the fact that these emergency orders change all the time. I might have heard it once or twice.
Yeah. So, Rod, it appears to be having a technical issue on his end, and wouldn't you know it, in our agenda that we had set for this, Rod was going to be the first one to speak, but maybe while we wait for him to sort that out, I'll just turn to our first topic that we're going to be covering tonight, which is, as everyone's getting quite used to, how we normally open these. We talk about reopening Ontario. And so I think what I'll do first is turn to our managers, Sean and Catherine, to see, maybe I'll start with you, Sean. How's it going on the AGM front? And are your corporations still attempting to hold or holding in-person AGMs?
We've, out of the corporations that we manage, we had, I would say, call them 3 outliers who had intended to hold in-person AGMs with different, either small groups or outdoors or something that seemed to fit the regulations. But of those, 2 have opted now for virtual meetings, and 1 did go through with it prior to the significant changes earlier in September. But in general, everyone is, other than the scramble to schedule an AGM, everyone's actually seems to be taking up the virtual aspect of the AGMs quite well, both adapting to the planning for it and enjoying the actual end result.
Yeah, and I would agree with you wholeheartedly, Sean. There's a lot of trepidation, and of course, we as a group got over that trepidation having practiced live in one of these webinars, so that we could get used to what the flow of an annual general meeting would be like virtually. I can tell you that, you know, all of the ones that I've attended, the ones that I've chaired, they've gone extremely smoothly. Kind of only joking, but it's funny because it's true. The only thing folks missed was the wine and cheese after that we usually are able to have. And the concern that certain folks mightn't be able to participate because they aren't really computer savvy hasn't been experienced at all. And the hosts, the moderators, the service providers have been exceptional at assisting anybody who's even a little bit leery or rusty on how to use electronic tools so that they can fully participate in the meetings.
Okay, folks. Well, I'm back. You wanted to kick me out. I think it's because I gave control to the twins tonight, and I think somehow they managed to kick me out. But look at that. They didn't skip a beat, and they actually are on script. Thank you, everybody.
Rod, I hate to tell you, but I'm actually drunk with power now, and I'm unwilling to give up my new seat as leader. So I'm going to go ahead and ask you the next question. Something Sean mentioned when he was talking was some changes to the laws with respect to COVID and you know the amounts of people that we can have in one place in September. Can you let everyone in on that and let us know how it applies to AGMs?
Well, look at that, eh? He's an expert. Merci beaucoup. Fantastic.
Sunset.
So last month, we told you that the emergency period came to an end, and as a result of that, all COVID postponed AGMs had to be held by a strict deadline. And parallel to that, the province told you, well, there's some limits to social gathering. That was a mistake to refer to that as social gathering, but it is what it is. And so some people out there, those wishing to play COVID roulette, who are looking at ways to continue to hold their meetings. You know, they decided that an AGM, you know, well, it's not a social gathering, so it doesn't really apply. Maybe it's a business setting. Others were finding ways to maybe meet outside using mega speakers. There was the drive-through AGM suggestion that I heard that got me laughing. And many, in any event, as Sean was saying a minute ago, went ahead and scheduled their AGMs, hoping for the best, hoping that they'd be able to hold them. Now, I call those AGMs nominations at the Rose Garden. That's what I call it now, where you just stack people up and hope for the best. Now, while these AGMs were being planned, what we didn't know is that September 17 came and there were strict limits imposed on gathering in Toronto, in Ottawa, and in Peel. And suddenly you had to be restricted to 10 people, indoor, 25 people, outdoor. And so the question became, do gathering limits apply to AGMs? And the answer is yes, unequivocally. These gathering limits are not social limits. They don't just apply to bingo nights and piñata parties. They apply to any monitored social gathering and any organized public event. Now, as chaotic as your AGM may feel, while you're in the hot seat, they are organized events. And so these limits absolutely apply to that. And so what are the limits now? Well, the limits right now across Ontario are, well, I shouldn't have said that, only in the special areas such as Toronto, Ottawa, and Peel. That's not across Ontario, but there's a big bunch of people in those 3 areas. It's 10 people if your AGM is indoor, 25 people if your AGM is outdoor. You cannot combine indoor and outdoor to bring it up to 35. And if it's partially indoor, not sure what that means, if the window's open maybe. If it's partially indoor, well, you're indoor. Now, there are some exceptions for businesses renting meeting places. And so if you, those exceptions, the 10 limit and 25 limit apply to AGMs that are held on location or in a public park for that matter. But if you bring your AGM to a business in the business of renting meetings spaces, then it's 50 people indoor and 100 people outdoor. Those are the limits now. Keeping in mind that there's some special areas in Ontario, the enhanced measure zone, Ottawa, Toronto, and Peel. And the reason why we're now having these enhanced measure zones is because once you're in the red alert level, there isn't another color, right? So they've decided we're going to be on the alert level, but some areas are going to be some special areas where we need a bit of extra help. So for those areas, there's further limits of 6 per table. People congregating outside at registration, for instance, would have to wear masks, and there's other limits for sports facilities. So that's sort of the long and short of limits on gathering. They apply. Stop playing COVID roulette. Stop looking for loopholes, and just fall in line. Resistance is futile. COVID is not a sprint. It's a marathon, folks. So there it is. That's my Bible thumping moment here. And so back to, I guess, to Sean and Catherine, how does that sort of take place in the trenches? So when I just joined back in, Sean, you were telling us that some people have finally accepted the hard truth and they're sort of abiding by this and they're all going virtual. Is that what I'm getting?
Absolutely. It's it's literally everybody. To the extent, and I saw the comments in the chat, it's become a crunch on the calendar to try to squeeze these in with third-party providers. So we find trying to accommodate our clients. We've gone to all different measures, including legal counsel locally, some of whom offer the services, as well as ourselves. We've done it with smaller corporations where it's a little more manageable. But it's all hands on deck to the extent that we have AGM scheduled on Sunday morning, Saturday afternoon, all the way through until December, well, into January, I should say.
Mm-hmm.
Right.
I'm going to play the tiny violin for property managers who don't get paid a surge fee for attending AGMs on Saturday or Sunday or Friday evenings now as you try to cram them in. The other kind of creative things that we're doing is looking to alternative hosts, as Sean said. Many of them won't have the electronic ballot capability, so it means a bit of a hybrid, the unicorn that no one's seen yet, where you're effectively hosting the annual general meeting as a town hall because all of your votes have been exercised on the proxy. I think the other thing we spoke of briefly yesterday, Rod, was in looking to put together an annual general meeting that was safe as opposed to fast. And so certainly if you're communicative with your homeowners, Francine mentioned in particular, what's happening if I don't have any notice of it, if I don't know what's going on. It's legitimately a problem to find a host now, particularly because of that emergency order that had a requirement that those virtual meetings take place before the 21st of November. So almost every company that I'm aware of are now booking into the new year.
Mm-hmm. Right. What about getting quorum? Is that a challenge in Ottawa and Toronto? I suspect no.
No, and it was mentioned in the chat, one of the benefits of having this Zoom meeting was that we had, more attendance than we ever did. Some of the feedback that we're getting back is that folks will kind of never go back to the in-person meeting. And the reason is you don't have to rush home through traffic to try to make the meeting. And if you happen to be at the cottage or one day we'll be able to travel again overseas, you can still tune in and still participate and you don't lose your enfranchised right to vote and make a difference in your community.
Right. And what about, I guess we need email addresses to be able to hold these meetings and to send the electronic ballots and to invite people. Is that kind of a challenge? Maybe Sean, if you want to go first, is that a challenge to gather email addresses? Anecdotally, I'm involved with a corporation with 225 units where they were very happy and proud to tell me that they had 17 addresses to start with. So that was our starting point. So how's it going in Ottawa on that front, Sean?
Yeah, and actually, while I do have one example that's comparable to that, it's definitely the exception. We've been pretty good. I mean, there's been even before the electronic communication regulations came in allowing electronic communication, we did tend to have a pretty good database of email addresses for owners. They were unofficial, they weren't legal addresses for delivery, but in the current circumstances, those are valid for the requirements of delivering notice of meeting. So that's been quite helpful, but there are still the odd outlier there that has not quite found the full participation on electronic communication.
Yeah, and I agree wholeheartedly with Sean. I certainly don't have any in my portfolio quite like that. But the official notice, the consent to receive electronic notices and things of that nature, again, if you missed it, this extension allows you to send the packages to folks electronically, notwithstanding the fact that typically they would demand a printed package. And so that is sometimes a confusion, if you will, over whether or not the corporation has an email address or not. So sometimes it's a bit of research, right? Who have you had an email from? Where does it go? And you're doing your best to connect as many homeowners as possible and to be able to validate those addresses.
Now, the thing is that this COVID crisis is pushing all sorts of industries, including the legal industry, including the court system and management into this century. And so we're all going to come out of this realizing that we can do this remotely and having many more email addresses, which is a much sort of faster way of getting the information out there. Okay, let's switch gears and let's go and deal with the AGM deadlines. And I'm going to turn to Graham for that. And that too has caused a fair bit of confusion because some deadlines are extended and some deadlines are not extended. So help us out, Graham.
Yeah, so absolutely. As many of our viewers will know, the extension that the province had given when all this first started was from until November 21st, corporations could hold their meetings or AGMs virtually, even if they didn't have a bylaw that allowed them to do that, which is normally what we need. And that also applied to the ability to conduct board meetings without every single board meeting consenting to it happening electronically. And it also allowed corporations to send notices of meeting or any other type of notice to owners by way of email or electronic communication, even if that owner hadn't consented to that. And so what we were dealing with as a deadline for that was November 21st, but I think a lot of corporations were really starting to feel the crunch to get these bylaws registered and passed by that deadline, which is fast approaching.
Graham, we can't hear you very well, actually. I don't know if it's just me, but...
is this better?
Yeah, slightly.
Okay, it's the best I got. So everybody listen close, because I'm only going to say it once, but it's recorded. And in any event, so the new deadline for these items is May 31st, 2020, or 2021. Well, I'm so used to thinking about 2020 that I typed 2020, but it is indeed 2021, and we'll get that fixed before this goes up. But yeah, no, don't worry. You don't have to go back in time to get this passed. Don't worry. So what's important to clarify, though, and what's led to a lot of confusion is that a lot of corporations got this update in the law and felt that, I guess now we have until May 31st to hold our AGM. We've been given more time. And unfortunately, no, you don't. The time limits to hold your AGMs are still unaffected. And so if your AGM was ordinarily supposed to be due during the quote-unquote emergency period, your deadline to hold it is still October 22nd. So you now have longer to hold meetings without a virtual bylaw online, but your AGM deadlines have not been changed.
Right, and so here you had in our slides our calendar showing you the COVID postponed deadline, I guess. So,
yeah.
And it's based on your year end. So find your year end, and that's going to tell you when you must hold your meeting. That's the deadline to hold the AGM. That has not changed. That has not been extended. What has been extended is the ability, as you said, the ability to hold them virtually without a bylaw. So you have more time to adopt the bylaw, basically.
And you can see here, too, that we made this chart before this change in the law came into effect because it's got November 21st, 2020 highlighted. But that should now be May 31st, 2021 as the new date to hold a virtual AGM and accept electronic voting without a bylaw.
Okay, so we'll correct that and we'll make sure that we post a corrected version. Very good. And as Catherine said, hold them safely, even if it means not quite on time. Now, one of the questions that we've been asked is, what can we do, or what can an owner do if the corporation doesn't call its AGM on time? Because some people may be still waiting for the vaccine, or they may still be waiting for the end of the pandemic. So, Graham, what can an owner do if they feel that the corporation is just dragging its feet and not calling the AGM?
Well, there are some options available to owners. As we've indicated before on this webinar, the Condo Act doesn't actually indicate that there's any quote unquote consequence to holding the AGM late. But that doesn't mean owners are without ability to make it happen. So if you are concerned that your corporation isn't holding its AGM on time and it's doing that for the wrong reasons, I think, like Rod just said, if it looks like it's going to be a couple of weeks late, maybe just for the sake of getting one of the third-party voting providers on board and availability, I can forgive that. I can live with that. But if it's an issue of, we are just going to hold out through this siege and wait till we can do it in person, we just have no idea when that could be, and that'll bring the corporation's business to a halt. So I think the most practical advice I would have for if it really looks like that this AGM isn't happening and it should, owners always have the power to requisition a meeting, at which point it could kind of kickstart the corporation into, well, we may as well just hold the AGM. And I mean, when all else fails, there's always recourse to the courts. That's the slower and the more expensive route. So I would hesitate to recommend that first. But and even before requisitioning, I would recommend just try to communicate with your manager, try to communicate with your board before taking such an action. Just see what's going on and see if they have an explanation. And based on what you receive or don't receive, you can make an informed choice. But yeah, owners are not left without tools to leave them stranded without an AGM.
Okay, I'm going to turn the mics to Natalia. In the meantime, Graham, if you want to sort of reboot your microphone or find an alternative, because you sounded like you were in a bunker somewhere. And
just so my apartment.
That's right. Natalia, we're going to turn to you now, our newest addition to this panel. And I'd like you to maybe help us understand the various, I guess last Friday, the province amended its reopening Ontario legislation, or the regulation adopted pursuant to that legislation. And finally, Ontario came out and said, you know what, masks are mandatory while in interior sort of areas of businesses and so on and so forth. So does that apply to condos, and to what extent, and what the devil's in the details? So maybe you can tell us a bit more about that, Natalia.
Certainly. So, of course, this new provincial mask policy and regulation applies to condo corporations, but there is some odd exception in the provincial policy that differs from many municipal policies and likely many condo policies that have been adapted thereunder. And that is this new dwelling element, that if it's in a dwelling of an interior common area, which a condo would be included, that if people are able to maintain a social distance of 2 meters, they don't necessarily have to wear a mask. And this is somewhat at odds with certain municipal policies, for instance, Toronto, that was adopted back in July 29th, I believe, and it required masks in all common areas, which would include the common elements of corporations. So although it's great that the province has taken this initiative to amend its regulations to make this masking mandatory, it will make a little bit of confusion for owners who will look either at the provincial policy and say, oh, well, I can maintain a 2 meter distance and I don't need to necessarily wear a mask in the interior common elements. Whereas Toronto's policy doesn't say that. And in Toronto especially, all condo corporations had to adapt a masking policy. And so more likely than not, that masking policy doesn't provide this odd exception that we see in the provincial policy. There obviously is the same exceptions that apply for other masking regulations, which include children 2 or under, people with medical conditions, and those accommodated under the Accessibility for Ontarians with Disabilities Act or the Human Rights Code. And also some exceptions with eating and drinking food, if you need some sort of procedure that requires your mask to be removed, and so forth. So although it's great that the province has enacted and amended their regulations to provide this, it will inevitably cause some confusion in condo corporation settings. So all owners, residents, or guests should, if they can, if they don't apply to one of those exceptions, wear masks within the interior common elements of corporations.
Okay, so this I think is yet another example of Dougie Boy's timid, confusing, and delayed approach to rolling out precautions and health restrictions. I mean, just look at Thanksgiving this coming weekend. I mean, you can't have it with your family unless you bring your family to a strip club or to a casino. And so that's sort of the Dougie Boy's approach to how we do this. Very timid and sort of a bit confusing. But I think your point is well taken that first, look at your condo corporation, whether it has adopted a policy or a rule dealing with masks. Then abide by that. If your condo corp has not, then look at your municipality. And many municipalities, I know Natalia, you spoke of Toronto, but I mean, there's tons across over the province, including Ottawa, of course. So look at the municipality. Has it adopted a restriction or an obligation with respect to masks and so on? And if it has, then you abide by that. Now, if the condo hasn't and the city hasn't, then you fall within the ambit of this new regulation at the provincial level, requiring you to wear a mask unless you're able to maintain a 2 meters distance. So that's sort of, I guess, the lay of the land on that front. How is it being approached in condos, or how are owners reacting in condos? Sean or Catherine, is it now difficult? Is that still contentious, or are people now sort of more comfortable with the concept? Or
we've certainly found that people have adapted well to it. The odd holdouts or difficult ones have generally been compliant when spoken to, as opposed to looking at enforcement measures or some sort of compliance efforts to force them to comply, which of course is difficult under the bylaws in Ottawa and the provincial regulations, where people do not have to prove that they are exempt from the requirements. So no, in general, it's been good. And as you mentioned, the city restrictions the city regulations can be more restrictive, not more permissive. So the provincial changes haven't had an impact on Ottawa condos. The only exception to that would be, again, if you had a commercial condo with a restaurant, there's a requirement for people to wear masks when lining up outside of a bar or restaurant, and that's a new one provincially. Right. At the same time, the City of Ottawa, Ottawa Public Health has recommended, not directed, not forced, but they've recommended that people should be wearing masks both inside and outside. So that's continuing advice from them, regardless of what the requirements are.
And Catherine, how do you sort of balance when you have an owner that falls into one of these exceptions, doesn't have to demonstrate that they do, but then you have the rest of the community that sort of, faces them in the elevator or the hallway? How do you deal with this?
It's always moral assuasion, right? And part of it is to foster an attitude of understanding and going so far, for instance, as determining right of way, if you will. So somebody who is unable to wear a mask, communicating to the rest of the population that we will consider somebody in the elevator as having the right of way to remain in the elevator, and asking somebody who is incapable of wearing a mask to please wait, or to ask somebody who is in the elevator if they're comfortable with sharing it. As you can well imagine, notwithstanding the fact that they may have an exception, it's trying to be sensitive to the fact that, folks coming and going, and with the cases being on the rise, we all have to work together. And I 1,000% agree with Sean. I think of all of the frontline workers, the hospital workers in particular, who are wearing the full hazmat suit, and for, hours, whole shifts, it's literally the least we can do to wear a mask, and at all times, whether or not our physical space is large or small. And I think that's one of the biggest tools we have currently to try to decrease the caseload.
Mm-hmm. And so, Jason, I'm going to turn to you because, we did bring you in from where your bunker. And so I guess you sent a very interesting email earlier this week, or was it last week? There's some new regulations that now do apply to employers, for instance, mainly based on the fact that if the provinces health authorities are recommending something, then the employer has to sort of follow it. So, like, help me understand that.
So the big announcement on Friday was quite interesting. That was the City of Toronto making that announcement, making recommendations to the province to allow them to either put those into place for those 3 enhanced locations or those enhanced measure zones. So these 8 points here really kind of sum up what I'm seeing and suggesting that's going to likely be very important over the next 3 or 4 days. So number 1 is all condo staff must be wearing masks everywhere in the building. We're seeing a lot of condominium concierge and security staff having the plexiglass, but they themselves are still not wearing the masks. That is a requirement. And in addition, if you're looking for evidence to support that, that individual is sitting in there for an 8 to 12 hour shift and breathing that lobby for 12 hours. There is nobody that's going to convince me to say that that plexiglass is safe. That plexiglass is a secondary kind of protection measure. The other thing is you're wearing the mask as an employee to also protect the residents within the building. So that plexiglass is just not providing that group protection. So masks are required in all areas, including common areas. The other rule that come into place is for all workplaces, no matter what sector this is, all workplaces must ask 3 questions of all visitors, non-residents, not the residents, but any trades or any visitors that are required to attend those locations. Now, while that is very important to focus on, I want to focus on the enhanced measure zones. So Toronto, Ottawa, and Peel. If you have a condo corporation in those locations, you should be screening all visitors to your property in those locations. And if you're not now, it will likely be required in the coming days, so be ready for it. But this is already a requirement in workplaces that just hasn't been talked about. And we haven't exactly clarified whether a condo meets that requirement. It does. It does, absolutely. So the third point is gyms. So there's been some discussion about gyms and group classes. So there are no group class exercise based on the recommendations from the City of Toronto on past Friday. So that's going to come into play. My suggestion and recommendation is if you're in the enhanced measure zone right now, you should be removing any group exercises already. If the City of Toronto doctor goes on national television and says they're recommending this, we don't need to wait for a law. You've got an authority having jurisdiction making that recommendation, and a proactive condo corporation should be implementing that, is my belief. The other thing is, if you're going to open up amenities, make sure the amenities been opened up with a 1-2 page document and the board signed off on the ad opening. I don't care if it's a 7-page document, 1-page document, the board should be signing off stating that they've reviewed the plan created by either the property management firm or an outside firm, doesn't matter, but the board should be approving that. Why? That's the kind of information we talked about several months ago that's going to be asked for, and it is going to be asked for. Party rooms, if you've opened them in the enhanced measure zones, based on Friday's announcement from the City of Toronto, the authority having jurisdiction, that City of Toronto health doctor came out and said, listen, the only way banquet halls are going to be opening is because if they have a detailed plan and that plan is approved by public health. So I kind of take those assembly areas, just like banquet halls. That's what your party room is. A party room, there's no way you can manage and effectively look after that party room. So if the City of Toronto doctors and public health unit are recommending that all banquet halls have a plan and that plan is approved, you're not going to go down that road. Those enhanced measures areas, they should be closing those party rooms. Security guards and building staff. In those enhanced measure zones, Toronto, Ottawa, and Peel, I don't believe we're going to see another mass lockdown. From what I understand, we're going to have a targeted increase of measures. That targeted increase of measures could result in people being stopped on the way or traveling within those areas. It's far-fetched, yes, but if you want to look after your continuity of operations, you should be planning for that. At least engage your service providers. Reminders on masks and social distancing. You know, Denise, Lash, and Natalia, you were talking about the mask requirements, and this is huge. The opportunity for your building employees to rely solely on social distancing and then stop, oops, I just broke the 2-meter range, and put the mask on. There's too much of a gray area there. There's too much for human mistake. So mask policies should be at all times for employees. Flu season is upon us. So what can we do as a condo corporation? Well, number one, I think it's very important that we review the cleaning schedules that we implemented almost 6 months ago. Why? Because those may change based on the demographics of your building, the traffic of your building, as well as several other factors. So my suggestion is that if I was responsible for a condo corporation, I should be reviewing those cleaning schedules at least every couple of months based on the new information that we're receiving and documenting that review. And then finally, fire safety is important. Why? We saw an increase during the enhanced measures of the lockdown the last time. So one of the things we're recommending is high-rise condominiums are required to do fire drills for staff every 3 months. Just make sure you're doing them. Make sure your staff are ready. And then finally, don't forget your annual reminder of the emergency procedures for all of your family of residents. This is so fluid right now, and I apologize for taking any longer than I should, Rod, but it is. And things are changing. We're constantly getting new information on a daily basis, but these enhanced measure zones, we have a real opportunity to implement a lot of these things now because they are being recommended. We don't need somebody to tell us to do these or that we have to do them. They're already being recommended by the top doctor in the largest city in Canada.
Right. Well, look at that. Very well said. Very well presented, Jason. I'm glad you actually could make it today. And so I guess I got a visual cue for what you just said about, stop looking for loopholes. If you're looking for a loophole, we got two right here. They go around your ears to hold your mask in place. Those are the loopholes. I found that on Twitter. It's not mine. Very good. We're sort of behind schedule, and so we're going to jump ahead and switch gears and talk about the new condo tribunal. And I'm going to turn to Graham first, who's going to sort of help us understand this new jurisdiction. And Graham, I guess this sort of came into play on October 1st. We have now this tribunal has a brand new sort of jurisdiction, and they're open for business to accept different disputes now. Tell us more about that.
Yeah, so not only are they open for business, but in fact, in any case where there is a tribunal that has a particular jurisdiction, it means that that tribunal has to be the first one that you turn to. So now, if you wanted to go to court or something about any of the new jurisdiction items, you would be told by the court politely, well, no, you have to go to the tribunal. And so what we were working with before with the CAT was just disputes with respect to records requests, but it's since October 1st been expanded to include pets, vehicles, parking, and chargebacks that the corporation has sent to an owner in respect of those items that I just listed. And so let me tell you, they've really run the gamut here with especially with the vehicles. They've listed everything under the sun that I can think of, including the obvious motorcycles, automobiles, to the less obvious punts. And under this definition, which is really quite broad, and you can read it on the regulation. But in my view, it would even include things like drones and horse-drawn carriages. So I'll move on quickly because I know we're short on time. But basically, if you park your horse-drawn carriage in a parking spot illegally and your horse is causing nuisance and you get a chargeback letter from your corporation's lawyer about it, it's the perfect case for the new jurisdiction because it'll cover all of their new areas. So I'll move on now and pass over the microphone to, I think, Natalia, who's going to talk a little bit about how the process actually works at the CAT.
Okay, and Natalia has extensive experience with the CAT, and so share the goods.
Yeah, so if anyone hasn't been a part of a CAT proceeding yet, it's essentially a 3-stage process that's done all online. One thing to note, it's very email heavy. So expect to receive a lot of emails when you're a part of this sort of proceeding. The first step of the proceeding is to start the application on CAT's online system. Prior to October 1st, it was only with records requests, so only an owner could really apply to CAT to bring this sort of proceeding. Now, a corporation could apply for this new jurisdictions that it's covering, that Graham just mentioned. So once an applicant files the application, the respondent will get a notice of case. At that point in time, the respondent has 7 days to respond, and they respond by accessing the CAT's online system and basically joining the case. And so once both parties are in the proceeding, you go to stage 1, which is negotiation. At this point, it's just between the two parties, whether it's the condo corp and an owner or multiple owners, and between each other, you try to negotiate and reach some sort of settlement. In my experience with CAT, it's not very fruitful, because by the time you get to CAT, there's already been so much communication between the owners and the corporation that negotiation won't really get you anywhere. So inevitably, it usually goes to stage 2. So the applicant has to pay the fees, and then you'll move on to the mediation phase. At the mediation phase, a CAT member will be assigned to the case, and that it's essentially like any other mediation, where the mediator tries to come to some sort of resolution between the parties. Generally, the CAT member will assign a deadline for the parties to reach some sort of settlement, and if they're not able to, then they'll open the case for the applicant to then pay the fee and move on to stage 3. One good thing with the mediation phase is the CAT member tries to limit the issues if it is proceeding to stage 3, which is good because oftentimes, for instance, in records request, there'd be 30 requests that are in dispute, and then you could limit that down to maybe 5 or 6 records. So once the applicant pays the fees, the mediator will then make a summary of the issues, and that will be provided in stage 3 to the new member that's assigned as the adjudicator onto that file. The adjudication is essentially like any arbitration or court proceeding. You have the parties submit evidence they're relying on, which in a records request proceeding would be the board's response, the records requested that were provided, any communication between the parties that they're relying on. Thereafter, you provide witness testimony. So whether it's the manager, a board member, or whoever who will be providing a witness statement to be submitted onto the CAT ODR system, they'll basically tell their perspective, expand on the evidence, and once that's complete, the parties have the opportunity to cross-examine one another, which also includes the opportunity to object to certain cross-examination questions. The adjudicator ultimately makes the finding whether or not to allow certain questions to be put forward. Generally, there's a second round of cross-examinations if they're necessary, and then the CAT member will also ask questions to both the parties if they need further clarification on any of the items. The last step is the closing submissions. In the closing submissions, you'll put in any CAT case you're relying on, other case law, and then the provisions of the Condo Act or the corporation's governing documents which support your case. The most controversial aspect, in my opinion, is cost submissions. Generally, CAT doesn't award legal fees for anything except if it's an exceptional circumstance. I believe that there's only one CAT case right now that actually has awarded costs. And oftentimes corporations use their lawyer to represent them in these sort of matters, which could rack up a big legal bill. And unfortunately, under the CAT's rules, they're only awarding these sort of legal fees for exceptional circumstances, which we haven't really seen thus far. But hopefully with the expansion of the jurisdiction, maybe they'll take this into consideration a little more if the corporation is the applicant and they have a strong case.
Okay, wonderful. So the first disclaimer that I have to put on the table is that this beautiful diagram that you see on the slide, I actually took it from the CAO's website. They have an amazing website where the Condo Authority of Ontario, where they sort of explain in greater details the process and what you need to do and how it works. And so that doesn't come from us. It comes from their website. It's full of good information. So if you want to brush up on any of that, that's a good starting point. And so a quick question for you maybe, Natalia, is that these cross-examination and this hearing and the submissions and all that, I mean, do we have to go to a courthouse, or how does that work?
No, so everything's online and it's done in writing. Sometimes the adjudicator will allow for oral submissions, but I think I've done 20 or so CAT proceedings at this point. I've never done anything orally. Everything's in writing, and it's all on the CAT ODR system. Actually, I think October 1st is when they updated their system, because previously it was a little bit confusing, but it's gotten a lot better since the October 1st changes, which is good for someone who's not very tech savvy like myself.
Right. And so it's pretty much all online now. And as you've indicated, there is these dispute, I guess these dispute, well, they used to be strictly about documents. And so when you look at that, I mean, that makes sense to make written submissions. I mean, did you ask for the documents? What document did you ask? Are these documents records? Which ones did you provide? That's like, I don't think there's a lot of sort of contentious evidence around that, I would think. But when we start bringing, pets and parkings and vehicles into the equation, and whether or not you're allowed to park your punt or whether you're allowed to park your horse and the parking, there may be more, like there's going to be a dispute as to the weight of your dog. If the issue is your dog is overweight, there may be issues surrounding whether this dog or this pet is a service animal. And so there may be a lot more nuances there. Now, you've indicated that it's very difficult, near impossible, I would say, to get costs once we go to the CAT. And so that may very well change, I think. It may level the playing field or certainly change the dynamics in the sense that it's less risky perhaps for an owner to challenge a ruling or a decision made by the corporation.
Yes. So, well, I guess now any dispute between the new jurisdiction will go to CAT. And if the applicant is a condo corporation, because in these record request disputes that we've seen, sometimes the applicants have been awarded some costs, or for instance, the cost of even applying to the CAT in and of itself and paying the filing fees. Maybe now that the tables are turned and the corporation might be bringing these disputes against condo owners, that the CAT will also be awarding some sort of damages or costs to condo corporations.
Right. I think that the default setting, though, for the CAT is that they're not going to be awarding legal costs, the legal costs incurred in the context of a CAT proceeding, or it's going to be very, very rare. So that's going to change things a bit, I think, which sort of brings me to you, David. You thought we had forgotten about you, but that brings us to maybe this year's case. The first instance decision came out in January, and already people were saying that was, the 2020 condo case. And the appeal decision came out probably at the end of August, the Amlani case. And the Amlani case, David, as you know, because you argued it successfully, dealt with cost and chargebacks, I guess. Can you maybe tell us a bit more about that and whether or not Amlani changes the landscape on the cost issue and chargeback issues?
For sure, and as you said, this has really caused some consternation amongst our peers. So I'm going to do my best to try and put out the different perspectives on it, and we can maybe talk about it a bit as a group also. So the Amlani case, in very brief, was about an owner who we represented who was a smoker, and there was no rule in the corporation specifically prohibiting smoking. And in 2015, there were some complaints about his smoking, and it was dealt with very swiftly and fairly by the corporation. They called in an engineer, they sealed off some risers, and there were no issues afterwards for 2 years. 2 years later, some certain complaints started coming in, and the corporation kind of changed its tune. And none of this is almost kind of like me editorializing. I'm really going with the findings of fact of the court. The court found as findings of fact that the corporation refused to discuss the issue with the owner. They refused to sit down and even call in any experts. They refused to mediate, seeing that as a threat as opposed to kind of a common sense solution. And when they did eventually go to a mediation, there was a finding that they left halfway through. So the court determined that all of this was all about how the corporation acted unreasonably. But the bigger thing here is about the legal fees. That's what this really came down to. The condominium corporation's legal fees that were charged for what was a compliance issue, i.e.
not following what they said were rules, or breaching the governing documents of the corporation, they incurred up to over $25,000 in legal fees. Some of those fees being after the owners had actually left. So the question was, can you charge back these legal fees in the context of a compliance matter? And a lien was then put on the unit when the fees were not paid, and then the application was brought by the owner to strike down the lien and for oppression and damages. He was successful in that application, and the court ruled that that the indemnification provision of the condominium's declaration was not broad enough, was not specific enough to cover this exact situation. So that's kind of one stream of thought. There was also a lot of discussion on the difference between Section 85 of the Condo Act and Section 134. So Section 85 allows the corporation to lien for common expenses. And Section 134 allows the corporation to get its legal costs back after achieving, being awarded an order for compliance. So a lot of the question here was, can you pre-charge someone for breaching a rule or for not being in compliance with the governing documents? Or do you have to first go get an order from the court ordering that they were, one, not in compliance with the rules, and then you can charge back for all of the reasonable costs incurred in seeking that compliance? So the court at first instance was pretty clear on it that the justice found that Section 85 and 134 are very different streams. You choose one or you choose the other. You can't mix them both together and pretend that compliance is a common expense, or pretend, or vice versa. They're really two separate streams. And the court, the divisional court on appeal, which was my first experience with a Zoom divisional court appeal, upheld this decision and said they saw nothing wrong with the application judge's legal interpretation. So the big takeaways from this, regardless of which stream of school of thought you're on, whether you think, as long as you have like a really specific indemnification provision, maybe you can, or if or if you're of the view that you can never charge back and lien for a compliance issue, the key takeaways from this is you just got to act reasonably. Like, the facts of this case were so ripe for the judge to just jump in and say, this corporation did nothing. They refused to meet. They saw mediation as a threat. They ignored all attempts by the owner to try and sit down and reach some sort of solution. And they continued charging legal fees once the owners actually moved out of the condo to appease the corporation, who was continuing to charge them legal fees. So all of that was viewed as unreasonable by the court. So you certainly want to be ensuring that you're acting reasonably in the context of any of your interactions with owners, especially in compliance. You certainly want to have your indemnification provisions reviewed by your legal counsel before you take big steps, especially when you're incurring fees. Don't just assume you're going to be able to get all that money back. You really need to review the indemnification provisions. You got to act swiftly, and you still, corporations, despite this owner-friendly decision, let's call it, corporations still have an obligation to enforce their rules. You just got to do it reasonably and in properly, setting out the steps and making sure that you're crossing your T's and dotting your I's. So maybe I'll invite anyone else who wants to jump in on this to kind of share their views. Maybe Rod also has some thoughts on this that I missed.
I mean, this is a fundamental question that we encounter all the time. So owner breaches a rule, corporation seeks compliance, the corporation then has incurred costs seeking compliance, and then the question is, who should pay for that cost? Should it be this owner that breached the rule, or should it be the rest of the corporation to absorb that as a cost of doing business? And there's been a lot of abuse where an owner feels that the corporation is acting as judge and jury, basically going forward with a compliance matter, and being able to sort of recover without any checks and balance. At least that's the perception. And so it's a very important question that's been adjudicated in the Amlani case. And I think we still have those two schools of thoughts out there. But as you pointed out, David, I think the starting point is, well, it should always be for the corporation to act reasonably, but also have a look at your indemnification provisions and have a look to see if, in fact, it provides you with the tools to be able to recover the fees. And if not, you may need to change your strategy about it. Now, we're not suggesting that you can never recover fees. And that owners will get a, don't pass go and don't collect, or as Catherine says, get out of jail free card. That's not what this decision is about. That decision was really about acting reasonably in the context and the factual context of this decision. But it's an important decision, and it may actually change the dynamics, how you sort of balance enforcement versus collection and so on and so forth. But we're not going to have a general discussion about that for the simple reason that we're running out of time. And so unless there's anybody that's dying to say something, I'm just going to go around and I'm going to thank all of our guests. I mean, if you want to know more about this decision or about anything else, feel free to everybody has blogged about it, except us, oddly enough. We're the only ones that have not blogged about MLANI for all sorts of...
We blogged about it. We had a few blogs on it.
We do, eh? Well, sure. Not at the appeal level. We wanted to see what other people would say about it, and we didn't want to really toot our horn too much, which we did tonight. Anyways, so going around the table now and thanking all of my usual guests for having taken the time to join us and share their knowledge and expertise. I'm going to go in alphabetical order, and you get about 15 seconds to share wisdom or parting thoughts. From Apollo Property Management, thank you very much, Sean Cornish, for your participation tonight. Any words of wisdom?
No, it's not a lot of wisdom. I think it's all been shared. The message, oddly enough, is consistent over the last 6 or 8 months. Let's not find the loopholes, as you said. Let's be cautious, and we'll all get through this. But we don't need to be jumping the gun and trying to get ahead of the game throughout any of this.
Wonderful. Thank you so much, Sean. Catherine Gao from Crossbridge, parting words.
Keep calm, wash your hands, sanitize your cell phone. We got a little bit complacent there. We were so excited to reopen. So let's step it back a little bit, give everybody more space, and be a little cleaner on those items.
And a guest star tonight for the first time on our webinars, Natalia Polis from Lash Condo Law. Thank you very much, Natalia. Any words of wisdom before we go?
Yeah, thank you so much for having me. It's a pleasure to be here. Words of wisdom. When in doubt, wear a mask.
Nice. Like it. I like it a lot. My two favorite condo twins, Graham McPherson and Graham, parting words?
Yeah, parting words from me. I'll take a step away from the...
Can't hear you, buddy.
Okay, well then, parting words from me. Make sure your microphone works if you're going to be doing a webinar.
Nice, very good. And the evil twin, David Plotkin. Hi, David. Any words of wisdom before we go?
I resent being the evil twin. I'm so nice. If you're unsure of what the municipal bylaws say and what the province is expecting you to do, pass a policy. Your policies are enforceable. The courts have recently, there was a recent Toronto case we didn't get a chance to talk about, but has upheld a policy that was passed by the Condo Corp in the context of COVID and said that it was a reasonable response to the global pandemic. So if you're unsure of which authority you're supposed to be following, pass a reasonable policy and then enforce it in a similar manner as rules.
Very good. Thank you so much. And big thanks to the National Life Safety Group, Jason Reed, for your very thorough review of these recommendations and how they apply to your condos. Words of wisdom before we go, Jason?
Listen, you've all been attending these sessions, and there's been hundreds in attendance every time. I wish you all a wonderful Thanksgiving with you and your families.
Wonderful. Thank you so very much. So folks, this is a monthly event now. Our next meeting is Wednesday, November 4th at 5 p.m. Information will be posted on the condoadvisor.ca. You'll need to register again. You can find information about our webinars, past and future, if you click on the webinar tab of the Condo Advisor blog. And if you have any topics in mind that you'd like us to cover, send them our way. We're always looking for good topics to discuss. So that's about it. I'm off. Thank you very much to the panelists. Thank you to everybody at home. Have a safe and socially distant great Thanksgiving weekend. Thanks so much. Have a great evening, everybody.